Good evening. This is John Milburn for Laws 12059 Conveyancing. Well, we've reached week 12 in term 2, 2018. Tonight we're dealing with week 10 material, remedies, and that relates to chapter 9 of your textbook. As always, when you're considering anything to do with conveyancing, have the standard contracts close by and always consider the terms of the standard contract in conjunction with and probably before you consider even the statutory provisions or the secondary materials like textbooks. So when we're dealing with remedies, we're talking essentially about things that buyers or sellers can do both pre and post contract. Almost invariably, we'll be talking about affirming or terminating the contract, in which case we then have to consider questions about dealing with the deposit, dealing with applications such as specific performance, and considering always ethical issues in relation to your task as a legal practitioner. So in the prescribed reading we have chapter 9 of land contracts in Queensland, but if you have access to the secondary or reference text, have a look at chapter 8. And you'll see that there are some key terms, and try to be specific about the use of these terms. Now, having said that, one of the terms repudiation is, I'm afraid, used in different ways by different judges from time to time. So when I first started to study in the 70s, very often repudiation meant something a little different to what it is typically means now. But usually what it means now is that where one of the parties renounces his or her liabilities under the contract, and that's the definition that you'll see in the study guide. As a result of that repudiation by one party, the other party, the innocent party if you like, has an option to either accept that repudiation or not. If the innocent party accepts the repudiation, it means that the innocent party may then go about terminating the contract. Now, termination of the contract is different from rescission of the contract. As you'll see in the study guide, in both cases, the parties are discharged from their contractual, in rescission of contract, there is a difference. And in that instance, and I'll look at the definition in the study guide, it says, where a contract is dissolved and the parties are returned to their original position as though no contract ever existed. We use the term termination in a different sense typically, and that is we talk about a party terminating the contract because of a failure to obtain finance. Termination in that sense is not putting the parties back to the original position. It's essentially acknowledging that the contract existed, but it has been brought to an end as a result of failure to comply or relying upon a special condition. So a slight difference there in terms of the way we use terminology, termination and rescission. You'll often see this concept of deficiency on resale. You'll see that in circumstances typically where the seller terminates the contract or declares the contract to be at an end, in circumstances where the seller is entitled to, amongst other things, declare the deposit forfeited. But usually the seller can go beyond that, and in relation to the buyer's breach, can sue for any shortfall or deficiency on the resale. So if we have a situation where the buyer commits to a contract worth $1 million, pays the required deposit of $100,000, and then for no good or valid lawful reason terminates the contract or fails to comply with the contract, then in those circumstances the seller can terminate the contract, declare the deposit forfeited, that is the $100,000, and if the seller is only able to secure a sale of, say, $800,000 on resale, sue the buyer for the additional $100,000 over and above the deposit. So that's what we mean by deficiency on resale and how it comes into context in these circumstances. And usually you'll see in the material, in the contract in particular, that buyers and sellers have a choice between remedies. the buyers and sellers can choose to affirm or terminate as a basic distinction. In terms of remedies, they might seek to obtain an order for specific performance, or relief against forfeiture, or sue for damages, or a combination of things. Now, when you're dealing with issues to do with remedies, always look at the contract. And in the standard contract, 14th edition, which is what we're using for this entire unit, have a look at clause 9, which deals specifically with the issue of parties default and provides that buyers and sellers may affirm or terminate the contract. And if the seller affirms or the buyer affirms, the options are laid out in 9.2 and 9.3, as opposed to termination in 9.4 or 9.5. And I mentioned resale, that's referred to in 9.6, and then damages referred to in 9.7 and 9.8. And always remember there's the issue of interest on late payments, so that the buyer is obliged to pay interest at the default rate for any failure to comply with the terms of the settlement. I say the buyer because it's the buyer that comes up with the funds. Therefore, if there's a late payment, that is going to be by the buyer, not the seller. I hope that makes sense. And the default rate is determined by reference to the Law Society rates as published, but it is possible under the contract to alter that and have a different rate prescribed rather than rely on the Law Society rate. But typically that doesn't happen in practice. I mentioned briefly before termination or rescission. When we talk about rescission, that is taking the contract back to the start as if it never existed. It's a remedy that's available in circumstances where there is a successful allegation of misrepresentation or mistake. Termination is different, and it's breach of an essential term or breach of an intermediary term or repudiation by the other party of their obligations under the agreement. In that case, the main case there is McDonald against Dennis Lascelles, 1933 48 CLR 457. So where the contract is rescinded, the contract is dissolved, the parties return to their original position as though the contract never existed. I hope that makes sense. And repudiation, as I mentioned, is where one party renounces their liability under the contract, shows an intention not to be bound by the contract or fulfill their obligations under the contract, or do something that's substantially inconsistent with those obligations. And the leading case, the one to always consider referring to, is Shevell against the Builders Licensing Board, SHEVEILL, Shevell, 1982 149 620. So coming back to the contract, I've mentioned clause 9, but you would see that under the contract, the parties have the contractual right to terminate in a range of circumstances. And that's not necessarily going to be because of the other side's breach of an essential term or an intermediary term. It may be termination as a result of something else. Clause 3, for example, deals with the issue of the ability to obtain or give notice of finance. Clause 4, the same, and then through on to clause 7.4, 5, 7.6, 7.7. Now, we dealt with those last week, and they're some of the main issues. At this stage, are there any questions that anyone has? Okay, well, we'll continue.
John,
Yes.
I've got a quick question.
Yes, Rachel.
If you're terminating for other reasons, like for instance, encumbrances, things like that, you don't forfeit the deposit, do you? Does the contract just come to an end? Is it only just because I know for finance, I mean that one you don't forfeit your deposit
No.
because
So
it
are
doesn't
you
get
referring in both instances to where a buyer terminates the contract, Rachel?
Yes.
Yeah. Okay. So in the first instance where there's a failure to obtain finance, for example, then the buyer has the right to terminate the contract, declare the contract no longer exists, and is entitled to a full refund of the deposit and an interest on that deposit if any accrued. If, however, there was an undisclosed encumbrance, such as an easement, then the buyer can terminate the contract, certainly recover the deposit, but may also have the right to sue for damages because the seller is in breach in those circumstances. So it may go a little beyond that, but certainly the deposit would be returned to the buyer as the innocent party in those circumstances. And of course, the converse applies. If the buyer is at default or is at fault, then one of the typical usual remedies, amongst other things, is for the seller to declare that deposit forfeited. I hope that makes sense, Rachel.
Yeah, I just started to think that there could be other circumstances, that it's getting a little deeper, that's all.
Okay, no, that's fine. I might just digress for a moment. Shireen asked a very good question on UCRU today, and I've provided a response. I'm not sure if you've seen that response, but I'll just run this by you. I'd be interested to see if you come to the same conclusion. So Shireen said, a question in relation to clause 4.14 of the REIQ house and land contract. Hopefully you've got that handy and you can look at it. If you're watching this as a recorded session, please look at clause 4.1 subsection 4. It's to do with building and pest. And it says that, for example, if a pool safety certificate has not been issued, the buyer may give notice to the seller, terminating the contract or waiving the benefit. The buyer must act reasonably. In the question, Shireen says, the buyer's obligation is to notify the seller of the outcome of building and pest by 5 p.m. So not strictly just pool safety, but if we look at, 4.14 deals with building and pest inspection. Sorry, I was looking at 4.2, pool safety. So 4.14 says, in relation to building and pest, that the seller may terminate the contract by notice to the buyer if notice is not given under clause 4.12 by 5 p.m. on the inspection date. So Shireen says, look, if you're acting for the buyer, I must inform the seller of the outcome of building and pest or waive the condition if that's what the client wants by 5 p.m. Is that correct? Any thoughts?
There's also the option of the continuing right that the buyer would have after the 5 p.m.
That's correct. So in those circumstances, if the buyer does not do either of those things by 5 p.m., then Sarah's correct in that the buyer has a continuing right to terminate, and that's referred to in the contract. What else might happen? So, and then Shireen says, well, is the deposit then forfeited if the buyer fails to notify about building and pest by 5 p.m.? It says that the buyer must give notice, so it looks like it's a mandatory provision. If the buyer fails to give notice, does that mean the buyer's in default?
I don't believe so. I think with the continuing right, they could still get the deposit back if they opt to terminate.
That's correct. So the mandatory provision, the use of the word must, is a little misleading there because it would suggest ordinarily that if you must do something, that you fail to do it by the time stated, that you're in breach, but you're not really. You have that continuing right, as Sarah explained, to terminate the contract. But come 5 o'clock, what can the seller do if the buyer has not given notice or waived the benefit? Any thoughts?
I was hoping someone else would have a go.
Yeah.
So they can terminate. Come 501,
Okay.
if they've not had anything, they can terminate. But they don't get the deposit. It still have
That's
to
right.
be.
They don't get the deposit. Exactly. It has to be returned. And until somebody does something, it stays there, and then it's a case of first in, best dressed, so to speak. All right, so thank you, Sarah, for that. And that is how I answered Shireen's question 3 minutes ago. Must have been just before we started. I don't know how that worked. No, before we started, but it wasn't 3 minutes ago. All right, so again, that emphasises the need to look at the conditions of the contract, read them carefully, but sometimes it could be a bit misleading. So remember, of course, that you can seek remedies at common law or in equity, and typical equitable remedies relate to things like a specific performance and declarations, and there are equitable principles or relief that might be available to do with estoppel or forfeiture. Now, are there any questions beyond that? Because I feel like I've covered this well enough previously, but I can go through it a bit more. I think we've talked about the different clauses in the contract. We did that last week. The measure of damages, I'm just looking through some notes. Buyer's improvements. That generally speaking, if the buyer does improvements to the property and then terminates, the buyer can't seek some sort of recompense for that unless it was contemplated in the contract, generally speaking. Remember the operation of the Australian Consumer Law. Consider Section 18 in general circumstances. And as we discussed last week, Section 70 of the Act is relevant for issues to do with short applications to the court to seek an answer in relation to questions. All right, so that's all that I propose to cover this evening. Unless you have any questions, perhaps about the assessment or any feedback about this unit or any feedback about the assessment regime. Any thoughts? While you're thinking about that, just a reminder, please consider giving feedback. It's important for me and the university. It's important for all your unit coordinators. So please, if you're doing multiple subjects, give feedback on all of them, if you would. Okay, so yes,
I was just going to say, I think I speak for most students when I say this, but your lecture techniques are one of the better ones that we've ever had, just because, I really enjoy the tutes, more so because you cover the content, you provide relevant cases which you explain, the relevant legislation, and then you give us a problem, and it just is more, just makes me feel a bit more involved when I do the course. In this and the landlord that I've got you in as well. So I'm doing 4 subjects this term, and your classes have been the most engaging to date.
All right, thank you very much. I appreciate that feedback. That's excellent. It's been a busy unit or busy term for me as well. I've had 4 units this term, which has been it's a record for me. All right. Yes, Leonie?
What are you teaching next term?
Next term, I'm taking Introduction to Law, Statutory Interpretation and Evidence and Proof. So I'm not sure if you've done Evidence and Proof with me. The other one is I take ADR quite regularly, and I take Environmental Law. So look out for those if you haven't already done them.
I'll see you in ADR.
All right, that sounds good. ADR is an interesting course, and my ADR students are busily doing their take-home paper as we speak. I just released it half an hour ago. All right, well, thank you, Sarah, for joining me tonight. Thank you, Leonie, for joining me. Thank you, Rachel, for joining me. And we'll sign off now. That'll be the end of the unit, and all the best with your take-home paper. I'll release that tomorrow night, 6:30. Okay, all the best. See ya.